Hi, I'm Sean Dong, Senior Lawyer and Director at Proactive Legal. We are a boutique law firm specializing in complex migration matters. Character issues are important for all visa holders in Australia. If a visa applicant or holder has a criminal conviction, it can lead to visa refusal or cancellation, and even a lifetime ban from entering Australia. So it is a serious matter. If you or any of your family member got into trouble before, you need to be very careful when you answer the character-related questions on the visa application form. All visa application forms have a character section with a list of questions. It's crucial to answer them truthfully and accurately. Any incorrect answer can trigger an issue called the Public Interest Criteria 4020, and it will lead to visa refusal and a 3-year ban from getting another Australian visa. You might think these questions are straightforward, but are they really that simple? Let's break them down. First, have you or any person included in this application? This means you are answering not only for yourself, but also for everyone included in your visa application, including your partner and children. All character questions are structured this way because it's one fail or fail criteria. Second, being charged with any offense. This includes any offense you've been charged with by law enforcement agencies, like the police. It's different from a conviction, which must come from a court. Third, currently awaiting legal actions. If these charges have not been dropped or decided by the court yet, you must declare them. If the proceedings have concluded, you may answer no to this question because it's no longer awaiting legal actions. However, there are some tricky situations. For example, an adjourned undertaking. It is where the court defers the final decision to a later date, requiring the accused to follow certain conditions. If the accused complies, the final hearing will be dismissed. The police check will show this matter as adjourned to a certain date. We've seen cases where the department issues a Section 57 notice on PIC 4020 grounds because the applicant did not tick yes to this question. We've successfully argued that an adjourned undertaking doesn't mean that the applicant was awaiting any legal actions. However, it's safer to declare it to avoid the accusation of providing misleading information under PIC 4020. Another confusing term is conviction. You'll be asked if you or any visa applicant have been convicted of an offense in any country. A conviction is different from a charge. A charge usually comes from law enforcement, while a conviction comes from a court. An accused might receive a without conviction decision for minor offenses. If you haven't received a conviction from a court, you shouldn't declare that you have. Family violence offenses is another confusing area. You'll be asked if you or any visa applicant has been charged or convicted of family violence or been subject of a domestic violence order. The policy explicitly states that an interim family violence order are also counted. Due to time limitation, we cannot cover all scenarios. Our advice is to read these questions carefully and ensure you have provided correct answer to the department. If you're unsure about a question, seek professional advice from a lawyer or a registered migration agent.